Good afternoon as you're joining us. Tim, it's 1 minute past 1. I think we're ready for you to start.
Thank you for that. Good afternoon, everyone, and welcome on behalf of Trust Mediation to this webinar, the next in our autumn and winter series. I'm joined today, as you'll see on screen, by my fellow Trust Mediation directors, Hesketh and Andrew Hannam, as well as Ian Cohen of the Cohen Consultancy, who works with us. The outline for today, we start with the deceptively simple question of what is ADR, and then look at how to advise on the different types of ADR, and looking at ADR orders, engaging with ADR, and then something on training. As usual, as you may have seen on your screen, we shall be recording this session. Questions and answers. We shall be happy to deal with questions as we go along. If you mention your name when you put your question down, we will identify you as the questioner, but anon is also fine. And we do welcome challenging questions. A couple of points before we get started. And if I can move on to the next slide, please. This is our next webinar coming up, 19th November, AI in personal injury and clinical negligent dispute resolution. So you might like to take a note of that if that's a subject that interests you. You'll see from the screen there that one of the speakers on that occasion will be Gregory Hunt of Hunt ADR. And if I can move on to his slide, he is offering a webinar course, a series of courses on AI for mediators. And this is primarily for mediators, but may also be of interest to litigators. As you'll see from the bottom of the slide, the next course that he's running is on 15th of December, and there is available a small discount on the fairly nominal cost of that webinar. If you'd like details of that, either see that on the screen or email training@trustmediation.org.uk, and we'll be happy to pass details on to you. So that completes the introduction. Let's move on to our first section, this question of what is ADR and what do we mean by ADR? Now, this may be counterintuitive to most lawyers, but ADR is a land of no authoritative definitions. You can't go somewhere and find out what ADR, alternative dispute resolution, or mediation means. You can look at the CPR glossary. The definition there of ADR is very broad. A collective description of methods of resolving disputes otherwise than through normal trial process. That is, anything other than trial. People who work in the business of ADR usually prefer a more specific definition or description, and this is where the box in front of you starts to have some meaning. This definition then, ADR is often taken to mean dispute resolution involving one of a number of structured processes, usually with the intervention of a third party, which do not lead to a legally binding outcome imposed on the parties. And if you look at the bottom of that box there, you will see the arrows showing you that we start on the left-hand side with negotiation and the routine methods of settlement. That is where there is most control by the parties. Moving across the page as we get into ADR, there is less control, but still a good deal of control, until we get to the right-hand side where you get a court trial, arbitration, or adjudication, when there is least control of the parties. And you'll see also how the three left-hand columns are non-binding and voluntary, whereas the right-hand side is binding. That, I think, is a good reference point to help understand what we're going to be talking about now, the different forms of ADR. The Lady Chief Justice, following the Churchill and the enhanced approach to ADR by the courts, has made this statement. Judges are increasingly likely to be called upon, further to the requirement to manage cases, to consider whether to mandate the use of ADR. And not just to consider the question of whether to do so, but also the broader question of which form of dispute resolution to mandate. So if the judges are considering these matters, practitioners will need to do so as well. So let's look at some of the different forms of ADR, starting with the most popular form, which Ian is going to talk to us about. Ian, over to you.
Thank you, Tim. Facilitative mediation, also known as standard mediation, this is what practitioners will be most familiar with. It's the most common form that's been used, and when it became adopted, in particular by the NHSR, there have been close to a couple of thousand of cases have been resolved by way of mediation. It's particularly relevant to be talking about mediation in ADR today, especially if anyone's had a brief look at the National Audit Office report, which actually came out today on clinical negligence costs, and talking about the need to be looking to reduce costs in the overall system. So the question is then, what is a facilitative mediation? And as it says on the screen, it's a neutral independent mediator who facilitates the negotiation process. Now, there is no one size that fits all, and it's up to the mediator to liaise with the party solicitors and to agree a process. Often one party will take responsibility for creating a bundle, and there may include a requirement to put in position papers, but it's very much up for negotiation, and it's very much up between the parties as to what they think will work. During the course of the mediation, there is often a usual three-room setup, which will enable the parties to, on the mediator, to shuttle in between the rooms and to have conversations with the intention of trying to facilitate a resolution. The mediator does not provide any legal advice or evaluate the merits of the case. What the mediator can do, if asked, is to provide an indication, is to try and look at ways to block log jams if requested to do so. And generally, it is a process to enable the parties to explore the issues and to try and reach a resolution. The statistics are that 80% of all cases that are involved with a facilitative mediation settle on either the day or shortly thereafter. One of the things, and I saw this from personal experience with the benefit of a mediation, was the value it can add to the process, which is over and above simply a financial remedy. So it creates an opportunity for the claimant to be heard. It's a safe space, and it gives the claimant a voice, and it also gives the opportunity to look at issues other than financial compensation, which could be to explore possible apology, sometimes face-to-face with clinicians, and also learning from mistakes and what has been put into place. So facilitative mediation is the one that's commonly used and commonly known by people, and it is getting traction within personal injury as well as clinical negligence. One of the questions is at what point in the process would you have a facilitative mediation? And the simple answer is at any stage. They take place pre-issue, they take place during the course of the litigation itself, and sometimes right before trial, and occasionally once a JSM has actually failed. So that's sort of the framework for what a facilitative mediation is. So if I can hand back to you, Phil.
Thanks very much, Ian. I shall talk about evaluative mediation, but just before I do, I'll just reflect on one of the things Ian was saying about parties and claimants in particular and what they can get from a mediation. I mediated very recently where there were impact statements delivered in an opening meeting that we'd arranged at the request of the parties. And it was a powerful experience. And at the end of the mediation, after we'd reached a settlement, there was a request from the parties to speak to the defendants to thank them for them and express the impact that the listening to them had on them. So just a reflection on that. But evaluative mediation may actually look very much like a facilitative mediation in the sense that the mediator will start the process in the same way, and it may be that the parties reach an agreement and a settlement and the agreement is drawn up and concluded and everybody goes home, it looks identical to a facilitative mediation. However, the parties have at their disposal the option to ask the mediator at any point to evaluate any of the matters that are up for discussion. It might be liability, it might be quantum or a particular aspect of quantum, and the mediator can express that opinion. And this has been agreed in advance of the mediation. Now, the mediator's opinion, evaluation, is not going to be binding. It may be influential on the parties, and it may be something they take stock of and then reflect on, and it may be that as a result of what they've heard, a resolution is found. That's the option. It's not necessarily going to happen, but it's there for the parties, should they choose at any point in the mediation on any matter that they're discussing, to ask the mediator to give that evaluation. Clearly, some thought has to go into the choice of the mediator in every mediation. You probably want to have some thought going into the choice of the mediator, but obviously, if it's a personal injury claim or a clinical negligence claim, you want a mediator who knows something about the subject, and that's one of the things we Trust Mediation have always had, that we provide mediators who are experts in that particular area. So it may be suitable, as I say, where parties want more than a directive and want more directed and structured approach, and want the benefit of an authoritative opinion from the mediator. So that's evaluative mediation. Andrew, can I ask you to talk about neutral evaluation for us?
Thank you, Phil. Yes, I will. A bit like yourself, I just wanted to pick up on something that Ian was saying about the potential added value of a mediation. And this emerged from a mediation that I undertook recently. It was a mediation in a high-value clinic claim conducted a couple of weeks prior to a liability-only trial, and it followed a failed JSM. So a couple of the points Ian flagged about timing and the fact that a mediation can certainly be contemplated and can add value when a JSM has taken place and failed. And I'm pleased to say that that mediation did produce a settlement satisfactory to everybody. So just underlining some of Ian's points. Turning to my topic of neutral evaluation, just to say that neutral evaluation is now something which is contemplated by NHS resolution. There is a contract in place for it, but we're still waiting for that contract to be activated. So it is very much something to watch this space on. So far as what neutral evaluation is, this is sort of the next step on, if you like, from what Phil was talking about evaluative mediation. This is when the parties decide early that they want to appoint an independent evaluator to give an assessment of the case. It's still a non-binding evaluation, so if the parties reject it, it cannot be referred to elsewhere, absent a prior agreement to the contrary reached between the parties. Again, following a theme that's been mentioned before, all the trust evaluation evaluators are specialist PI and ClinNeg mediators with experience in litigation in that field. Just a couple of thoughts on the practicalities of a neutral evaluation. The parties will, as with a mediation, be required to produce an agreed bundle. In addition, the parties will provide submissions. Now, those submissions, if you like, would be matched by a position statement in a mediation, But of course, a submission is a much more argumentative and document that seeks to be persuasive, because in a neutral evaluation, the evaluator is expressing an opinion, in contrast to when you have a mediation. Again, a further wrinkle in the potential process, the neutral evaluation can be undertaken solely on the papers, or it can include hearing written submissions. So that, I think, is what I really wanted to say on neutral evaluation.
Thanks, Andrew. Before I pass on to Tim to talk about mediation with evaluation, I've had a question about where we can find details of our evaluators. They're on our website, and just Andrew was saying that although the contract in relation to NHSR evaluations is not yet activated, we do take instructions on in personal injury matters, for example, or non-NHSR evaluations. And yeah, details are on our website, or just drop us an email to the registrar address, which I'll put in the chat in case you don't have it, and we can send details to you. Thanks, Tim.
Tim, you're
on
muted.
mute.
Thank you. Too many buttons to press. Apologies. So I'll start again. Mediation with evaluation. This combines, as the name suggests, both of these topics, facilitated mediation with evaluation. And there are various ways that the two can be combined. One which is used and has been talked about by one of our evaluators, David Pittaway, KC, goes in this way. He starts the mediation, starts the day with a mediation in facilitated mediation style, listening to the parties as they discuss the case. Having done so, and usually by this time it's the end of the morning, he moves, he takes time out to prepare a written evaluation, which is his evaluation of the case and the matters that he has heard and seen. He then goes back to the parties with that as a draft evaluation, to put it to the parties, and to discuss it with them. And experience tells us that when neutral evaluation is used, it is not very commonplace for both parties to immediately accept that and settle the case there and then. The evaluation is a tool to facilitate the discussion. And David Pittaway has found that to go on then to have a facilitated mediation and discuss his evaluation with the parties usually leads to a settlement of the matter. And I say settlement because these mediation plus evaluation, these mediations that he runs in this way are run between parties who have made a decision they want to settle the case, but it's how the case is going to be settled. And so far there has been a very good outcome in terms of the ones that have been run. This also, I think, shows how ADR is a very flexible tool. I mentioned earlier on there are no definitions, and it is really a set of tools or techniques that can be used on a mix and match case-by-case basis, where a skilled neutral who is used to the ADR tools can work with the parties and help them find the best outcome. Thank you.
Thanks, Tim. That leads us on to arbitration, and with arbitration, we're getting to the right-hand end of the spectrum of that diagram that Tim started off with a lack of control, in the sense that you're putting the decision in the hands of an arbitrator, and that decision is going to be binding. So it's a confidential process. The evidence is submitted to the arbitrator along with submissions. Depending on the process involved, it may be on paper, it may be orally, and then the arbitrator will assess all that and make a decision which, as I've said, the parties have agreed in advance that it's going to be binding upon them, and is typically enforceable in court. So that's the furthest end away from your negotiating and your facilitative mediation end of the of the ADR spectrum. Tim, mediation with arbitration?
Mediation with arbitration, yes, there is again another variation on this lines, and I've known arbitrators who will prepare their arbitration decision, but then put that in the desk and have a mediation session with the parties on the basis that they have an option to arrive at a result which they control, they have decided between themselves, assisted by the arbitrator who joins the discussions. This is unlike facilitative mediation in the sense that there is a definite outcome to the case, because if the mediated discussions do not reach a settlement, then one party can opt and say, well, I want to go for the arbitrator's decision, in which event the arbitral decision is produced, and that is an arbitral decision in the usual meaning of the Arbitration Act, which is a final and binding decision. So that's another permutation of how ADR can be used with an adjudicative process.
Thanks, Tim. I think that gets us to the end of the spectrum that we've gone through and all the different potential processes that you can have in ADR. So how do you choose which one? And for this, I'll bat over to Ian, I think.
Thank you. Well, I think the starting point is, if we take a step back, the number of choices are quite substantial. And for solicitors, choosing the right one can be quite difficult. So what I would encourage is that if you think mediation of one form or another will be of benefit to your client, then speak to Trust Mediation, talk to them about the issues, and then work through what you think will be the most appropriate one for your client and the situation that you are in. I'm going to talk a little bit more about facilitative mediation and the cases where I think it is appropriate. Again, these are facilitative mediation, are the mediations within clinical negligence that have had the most traction, and the one which the NHSR was and has been pushing for a number of years. The general point to make is that facilitative mediation can apply to all cases, whatever stage they're at, and whatever quantum those cases are. I've been involved in cases whereby mediation has been used in lower value cases that are highly emotive, to do with neonatal deaths or possibly even the deaths of an elderly parent, where the financial side of the resolution is not that critical to the claimant. It's more about the apology, the lessons learned, making sure that their voices were heard. And I do believe that there are a number of cases, the lower value type cases, that are highly emotive, that really do lend themselves to mediation, and clients get real benefit from the process. They feel involved, they feel that their concerns have been listened to, and that the people that have died quite often are, there is a voice to express the concern, what's gone on, in order to ensure that lessons are learned. So it really does help towards that. The other end of the spectrum is that it really does lend itself to high value cases as well. And it can be cerebral palsy cases, for example. We could have a situation where there is an admission on liability and causation, where we've got a reasonably good understanding as to how the case will map out from a condition on prognosis and quantum point of view. And that, rather than then just going through the process of a court timetable or a JSM, which quite often has all sorts of different criteria that come in, ranging from the time of year to what it is that a particular leading counsel is looking to achieve from it, then utilizing a mediation, facilitative mediation, in the complex high value cases can really produce really good results and quickly. And again, there have been examples of catastrophic injury cases resolving by facilitative mediation pre-proceedings. Now, obviously, on those type of cases, there would then still need to be an approval at some point, but nevertheless, it's still a much, much quicker process to go through. So I would encourage everybody to think about what is it that the client wants to achieve and how we best to achieve it, which one will we choose, and the one that we are most common with using as practitioners is the facilitative mediation. Andrew, would you like to talk a bit more about the other ones?
Yes, I would, Ian. I just really wanted to just to emphasise some of the points that probably have already been made about the evaluation process. Firstly, if you are thinking about an evaluation, that's something which you do need to agree specifically with your opposite number in advance. The other thing that I just wanted to emphasize is there will be occasions when the need for a timely resolution is recognized by both sides. And in those circumstances, having the slightly more directive nature of an evaluation can influence your choice of ADR options. And then the other thing that I just wanted to sort of put out there really is a further sort of subtlety around evaluation, which is this, that sometimes a mediation will be proceeding. The parties do not quite get to the stage where it can settle. But the mediator, based on what he or she has heard during the mediation, can evaluate where that mediation could/should settle. Now, that's a slightly subtle variation on where the evaluator will look at the entirety of the case and look to issue an evaluation based on what the evaluator thinks would be the likely outcome at a trial. So there's a subtle difference between the two, but worth thinking about. One, when you're inviting your mediator to offer an evaluation based on what they've heard at the mediation, so where they think it would be appropriate for it to settle, and the perhaps more pure form, where the evaluator is looking at all the facts, all the arguments, and offering and issuing an evaluation similar to a trial judge at the end of a trial. Those were the thoughts that I just wanted to share on ADR processes, conscious, as Ian said, that facilitative mediation remains by far and away the most popular.
Thank you, Andrew.
So,
yeah, thank you. So Andrew and I are just going to talk a little bit now about court-ordered mediations, and the reason we can talk about this now is because of largely because of the case of Churchill and Merthyr Tydfil, which most of you, I'm sure all of you, will be familiar with, not least because we've covered it on a whole webinar previously, and then last year we revisited it because the CPR was changed to reflect, put the CPR in line with the decision in that case. Just very briefly, the first instance, it was thought that the Halsey decision from 2004 prevented the court from staying proceedings and ordering the parties to take part in some form of ADR, be it mediation or any other. The court said that, in fact, the Court of Appeal said that, in fact, the courts can order parties to take part in a form of ODR, mediation, or whatever it is, but it wasn't prepared to set out a whole checklist of reasons why you would have to do that. So, has it happened? One of my roles at Trust Mediation is to look after bookings that come in. So and we always ask the parties who has instigated the mediation. Is it the claimant? Is it the defendant? Or is it court ordered? And as you can see, last year, 2024, it was a pretty even mix between claimants and defendants who had initiated the mediation, and the court ordered was around 0%. To date this year, that percentage has gone up to 9%. So obviously, it is starting to happen, and the rate of it seems to be increasing as well. I just given you other information that the breakdown of our the case types that we mediate. You'll see in 2024 was the vast majority of the work we were doing was in the clinical negligence field, and this year there's been a substantial growth in the number of personal injury mediations that we do. So you can see now that the percentage has gone up to 15%, and I'm sure that's connected to the statistic above relating to the increase in court-ordered mediations. Now, one court in particular where this is happening is in the Southwest, and I shall pass over to my regional expert, Andrew, to tell you about that. Thank you.
Thanks, Phil. Well, I'm delighted to talk about this initiative in Bristol. It's something which, with another of my mediation hats with the Association of Southwest Mediators, we work very closely with Alex Rolton, judge at Bristol. It was something that we worked with him for a long time. And I have to say that initially he was quite nervous about it. This was well before Churchill had been heard. And I think he was a bit nervous about going out on a limb. Nonetheless, he very much understood the benefits of mediation. And we did run a pilot in Bristol. It initially had a slow take-up, but I was in touch with Alex just yesterday, and he was saying that the number of applications to effectively disapply his order are now vanishingly rare. So it is becoming very much an accepted part of practice in Bristol. What you have on the screen at the moment is the first part of the order. And the first thing to note is that this applies to multi-track cases, and the claim will be allocated to Judge Rolton, as it says there, through until the listing of any CCMC. And the effect of the order is to stay proceedings for 3 months to enable mediation to take place. As clause 3 says, any party may apply to extend that stay, because sometimes it does take a little bit longer to get the mediation sorted. And if we can move on to the second part of the order, what I think is really important is that at the expiration of the stay, the parties at that stage have to explain why it has not taken place. And I think that's really important because up till now, that need to explain has probably been deferred until after a trial. And we all know that the percentage of cases which actually go to trial is very small. Whereas what this order does is it very much brings that focus forwards, so the parties know that come the CCMC, they're going to have to be explaining and justifying why a mediation has not taken place. It also requires the parties when a case has been settled, to provide a schedule of the terms of settlement to the court. And that's important from a practical point of view, because it enables the court to keep a track of those cases which are settling pursuant to this stay. And again, based on what I was told yesterday, is that the percentage of cases which are settling pursuant to this order for a stay is increasing steadily and very much going in the right direction. If despite mediation it hasn't settled, then you're back into CCMC, directions are made, and you're back into litigation. Now, together with the order, the judge has prepared some explanatory notes, which set out, firstly, the authority for the judge taking this proactive step. And he refers firstly to Rule 1.4 in the overriding objective, which now requires the courts to actively manage cases, including encouraging the parties to use an ADR procedure. So that sort of sets the scene as to the authority for this. Then number two is almost self-explanatory. It certainly is to those of us who mediate, either as mediators or regular advocates in mediations, looking at the benefits of resolving matters early, and the potential of mediations bringing about an early and sensible compromise of the case. And if not a total resolution, then at the very least a narrowing of the issues. The court quite rightly recognises that there are some cases which aren't appropriate for mediation. My own view is that the cases which aren't appropriate are going to be very few and far between, but the court felt that it was right and proper to make that modest caveat. For paragraph 4 of the explanatory notes, that gives the parties the opportunity to apply to have the stay set aside, and that, as I said earlier, whilst initially parties were regularly applying to set aside the order to stay, those applications are now becoming vanishingly rare. The final paragraph makes reference to initially approaching ASWM, because we worked with the judge at the time, or any other provider of mediation services of your choice. So it's very much for the parties to sort out how they choose to mediate. But it is a scheme that's been in place for a long time. I think the judge feels now very pleased with himself for having started it before Churchill, and now feels exonerated by Churchill. So,
thank you very much, Andrew. I'm going to ask Tim now to tell us what is meant by engaging in ADR, and why does it matter?
Yes, this we're going to look at the two aspects of engaging. The first up on your screen there is the new part of 44.2, parties' conduct, and with the Churchill amendments came this new one, E, where a party has failed to comply with an order for ADR or unreasonably failed to engage in alternative dispute resolution. So there's going to be interest in what engage actually means. There are some fairly obvious examples that a party who refuses ADR or is silent or drags their feet, there's plenty of case law along the lines to suggest that is a failure to engage. An interesting point arises as to the extent to which the court will look at what the parties actually did during ADR. So far, that has been treated as confidential and without prejudice by the courts. And of course, there is a contractual confidentiality in the agreement to mediate. But there have been some examples where the court has lifted the veil, and there are a discrete number of examples where that's happened. I'm not going to go into the detail of those, but I think there is an interest to see whether a party that turns up to a mediation and folds its arms and says, well, I'm here, but I'm saying nothing, so you can't say I haven't mediated. Is that kind of conduct going to be looked at by the court? That, I think, is an open question. There is an unreported case of a party which a defendant suggested a JSM, and at the JSM took the folded arms position, saying, well, we're here, but there's no offers. You can say what you like. We'll listen to you, but we're not going to make any offers. And there was a costs order against that party. So that is an interesting area of territory to watch. The Appia case was preceded the CPR amendment we've just been discussing, and this concerned the interpretation of a court order. As you'll see, the parties were ordered to consider ADR, and any party not engaging in any proposed ADR must serve a witness statement giving reasons within 21 days, etc. So following that order, there was an exchange between the claimant and one of the defendants. There were, as you'll see from the citation, a couple of defendants involved. I think this one was an NHS trust. The claimant proposed ADR. The defendant's response was they were prepared to engage, inquired what form of ADR the claimant had in mind, and went on to say that we need to consider your expert evidence first. The claimant responded that mediation was the proposed form, and there the correspondence closed and then fell to be considered by the court shortly afterwards. And the court found that although the defendant had said they were prepared to engage and inquired about the form of ADR and said they wanted to see the expert evidence, the court said they had not engaged in the sense that they had, because they had not engaged, they hadn't served a witness statement within the 21 days, and that meant they were in breach of the order. It wasn't that they had refused to engage, it was that they simply had not engaged. The court said this defendant did not begin to engage in ADR within 21 days of the claimant's proposal. They expressly stated that their view was that expert evidence should be served first. The outcome was, not in this case a cost sanction, but an order that the defendant provide a witness statement explaining its position, and all parties were once again ordered to reconsider mediation. So the conclusion from that, and from a number of other cases as well, is that parties must not only consider mediation, but actively engage with it. And should they not engage or decide that ADR or mediation or whatever other form is considered is not appropriate, they need to provide explicit written reasons for not doing so. The courts have said that silence about ADR and foot dragging are unlikely to be interpreted as engaging. So that's the general principle, and lawyers and heads of departments supervising lawyers need to be acutely aware of the case law on this when offers of ADR and refusals are made. Now the query arises in Appia: could the defendant have avoided the problem by simply serving a witness statement saying they wanted to see the expert evidence first? Would that have got them off the hook? And the case law goes both ways on that. The PGF case in 2012 said that waiting for expert evidence to enable the party to evaluate the case was not a legitimate reason to refuse mediation. And here the court was saying that you don't need an oven-ready trial bundle to settle the case. And that point is underscored by the fact that over 50% of trust mediations are carried out pre-proceedings. the court put it this way: either parties know or are prepared to assume that certain facts will be established, or during the course of such mediation, such information is available, often on a without prejudice basis. It might well be a legitimate reason for postponing a mediation if essential information was requested and refused. And what the court was saying here was that if you get an offer to mediate and your response is, yes, we'll mediate, but later, that on its own is not good enough. You need to give explicit reasons relating to the particular circumstances of the case in writing at the time of refusal. Now, there have since been a number of cases. The first one is 2014, but the other two were in the last few weeks. In CRP Properties, a construction case, the court envisaged that mediation should be delayed until after disclosure. The case just a month or so ago, IBM Lithgow, that was a professional negligence case, and the court ordered there that the mediation should be delayed until some particulars of claim had been served, so the party knew the case that it had to meet. And similarly, in Ellis and Ellis, which was a very recent case in the last week or two, it was held perfectly reasonable for a party to wait until after the CCMC to consider whether mediation was appropriate at that stage. This was particularly so because the party seeking mediation had refused to disclose evidence in support of his case and was uniquely positioned to know the evidence that he had available in support of his claim. So with good drafting and careful attention to the authorities, it is perfectly acceptable to refuse ADR or to postpone it to a later date, but only on that basis. I can provide the citations if anyone's is further interested in those.
Yeah, Tim, there has been a request for the citations. So how will we do that? I don't know if you're able to put them in the chat, or should we send them out after the webinar's finished?
We'll send them out. I can send them out with my note on Appia, which contains all the citations. So I'll do that.
Thank you.
So moving on, there will be an increasing interest in ADR. Andrew and Phil have spoken of ADR orders being made. We're seeing them in the office at Trust Mediation as parties seek information about mediation and say that they need to mediate within a certain time because that is the date the court has given. Now, some people, certainly in the clinical negligence field, are quite familiar with ADR and mediation, but not so familiar with other types of ADR. And the personal injury sector has relied almost exclusively on either routine settlement, Part 36, or JSMs, and mediations are being ordered. So with that in mind, what Trust Mediation has done is to offer a free service to firms of solicitors who would care to appoint an ADR champion. And the idea is that person, usually a senior solicitor, a legal executive, an associate or a partner, becomes that firm or that department's go-to point for trust mediation and vice versa. And information, training materials and so forth will be provided to that person, who will then be equipped to deal with inquiries from colleagues or clients about ADR. So this is a service which we're offering. There are benefits for the firm, and again, we can send further details of this out after the webinar. It has been fairly popular with the firms that we have been talking to date, and the way of keeping their training up to date. Now, in tandem with that, we have introduced, again with the increasing interest in mediation, and this concentrates on mediation rather than ADR at large. And this is an e-learning module designed for lawyers who deal with personal injury or clinical negligence claims, and is suitable for that. It's suitable for a refresher for people who've not dealt with mediation recently, and is also useful for onboarding new joiners to a department. There is an introductory offer, as you will see there, which is open until 31st October 2025, and that is in respect of a premium training package, which includes the module itself and a follow-on online training session. Again, we can send details of this out, but for firms that, be they claimant or defendant, who feel that they've not had much involvement with mediation to date, but would really like a hands-on, fee earner centred approach to what actually happens, what do you do when an ADR order is made, how do you prepare for the mediation, how does it all work, then these training packages may be of interest to you. So that concludes what I've got to say, and we are in time, I think, for questions. If you have any questions arising from any of the matters we've discussed today, we're happy to try and field them. Phil, I don't know if there are any questions in the chat remaining, or whether we've dealt with them all the way through.
No, none in the chat. I'll just leave it for a moment if anyone would like to submit anything. Otherwise, we can let you go early for lunch, which on a Friday is probably welcome. Okay, I don't think there's any questions coming in. So thank you all very much indeed for attending today. We will put a copy of this recording up on the website for any colleagues who've missed it and wish to see it. So we thank you again for attending. Thank you to all my colleagues for the work they've done in preparation. And we hope to see you at the next one in late in November on AI in dispute resolution. Thank you all very much. Have a lovely weekend.
Bye.